Here at a conference like this, when we are going to flag some of the issues of the intellectual property rights, and we want to get a kind of a meaning of what the emerging trend is. So I'll just begin with this caveat and with this context is dwelling upon something on the copyright law and what are the emerging trends which are appearing. As a student of intellectual property, when we read Indian copyright law or the copyright law per se, at a comparative perspective, what we find that there is one of the trend is to balance and harmonize the economic rights and the moral rights of the authors, as it has been witnessed by the case law of Amarnath Sehgal and Manu Bhandari and the Kerala Literary Societies. What we find that the copyright law is not meant for state purposes. The copyright law is meant for the dissemination of information, and the broader objective of the intellectual property remains the greater social common good. And that's why it is not purely economic, but the authors have their inherent moral rights to see that their works and their creativity are not mitigated, defaced, and defiled. And that right is so sacrosanct that the Indian copyright law has been very conservative in protecting the moral rights of the author. The another issue of the copyright in the emerging trend of intellectual property, in my opinions, appears to be the doctrine of fair use. Now, we generally see that whether the doctrine of fair use, which has been incorporated under the US copyright law, got a prominent place in the Indian copyright law or not. And we are quite aware of the Napster's case and MGM case, the Sony case, and the entire dilemma of the time shift and the space shift, and then the violation of the copyright law, and then how the US Supreme Court has evolved the doctrine of fair use. In the Indian context, as we find the doctrine of fair use as being obliquely recognized, not per se, but there are certain circumstances which justify that the Indian law of copyright also favors what is called the doctrine of fair use under the section 52 of the copyright. A student of the copyright law, when reads section 51 and section 52, then one can compare and contrast the basic ethos of the Indian copyright law, that what constitutes infringement and what does not constitute the infringement. The list of the what does not constitute the infringement under the copyright law is something very massive and broad, and one of the most vociferous articulation of the doctrine of fair use in the Indian copyright law we have witnessed into the Rameshwari photocopying case, or what is called the Delhi copyrights case by the Delhi High Court and the Supreme Court of India, which have given a very liberal interpretation of what is called is section 52 subclause 1 subclause I, which talks about that teacher and the people relationship and the course of instruction. And the Supreme Court, while interpreting the course of instruction, finds a photocopier kiosk in Faculty of Law center, campus law center in New Delhi University as coming within the purview of the course of instruction. One may agree to this decision or one may disagree with this decision, that in the teacher taught relationship or in the mentor mentee relationship or educator and educatee relationship, how a copyright kiosk or the copyright owner, sorry, how a photocopier kiosk or the photocopy owner appears to figure into the entire ambit and scope. But nonetheless, the Supreme Court and the Delhi High Court have unequivocally have given a very liberal and very relaxed opinion about the course of instruction. And then the Cambridge University plays, the Dillon Francis and Oxford University plays, who were very perturbed by the massive uh, photocopying of their books and to be sold at a very uh, reasonable price and a low price was something is a case that has to be reconsidered and to be relooked that when India has already embarked on privatization of education, such a liberal interpretation of the Supreme Court does not appear to be in tune with the massive stride which the Indian education system is making through the private university and the commercialization of education. Then there are certain other emerging trends in the copyright law, which talks about the neighboring right, but whether the neighboring right law has been suitably amended to give effect to the WIPO phonograph treaty or satellite convention or the Rome Convention, and what are the pitfalls and the promises in recognizing the neighboring right under the copyright law and its consequent amendment in India to come very closer to the European Union directives on neighboring right, which gives various shade, hues, and colors to the creativity of the individual or the writers and the authors. The other issue on the copyright law in the emerging trend of the intellectual property appears to be the digital right management, the onset of the digital right, and the entire opposition and entire lobbying of the music industry in this country to get a space in the Indian copyright law to have the digital atmosphere and digital right management. We are quite aware about the Javed Akhtar specific amendment to the copyright law in 2012 and 2014 to confer some very uh, major space and leeway and leverage to the Indian music industry. But still, there are certain issues that needs to be resolved because the Indian music industry is one of the industry which has been reeling under a fear psychosis and a victimization of the liberal impact of the digital right